The next bill on the calendar is...
Mr. President? Thank you, Mr. President. Mr. President, I request that we return to page 5 of today's calendar and we begin consideration of House Bill 963.
Leader Corman requests that we return to the calendar and begin with House Bill 963. Will the Senate agree to the bill? Agreed to. This bill has been considered on 3 different days in open Senate and is now before the Senate for final passage. The question is, will the Senate finally pass this? Yeah. The chair recognizes Senator Muth.
Thank you, Mr. President. It's never too late for justice. Mr. President, I stand here today not only as a senator, but as a rape survivor, an advocate, and as a woman who will never stop fighting for justice for survivors. If we can look closely at ourselves today and listen to the stories of struggle and wisdom of others, we can change the world. But sadly, today, I'm concerned that a vote on this bill, we will fall short. We will be settling, and many have waited far too long, and a compromise is unacceptable. Those who say that a constitutional amendment route for an incomplete abolishment of statute of limitations that still has an age limit on reporting and exclusive age of victimization is better than nothing should know that we the people, the survivors, the families, and friends of survivors know more could have been done and should have been done. A deal made by lawmakers who are leaving many victims waiting for their rightful path to justice and healing, and leaving many victims out of the deal just because of when they were victimized. It's not a good deal. I have yet to get an answer as to what the difference is as to what age you were raped at versus another age. Why is some arbitrary number used to determine whether or not someone is worthy of being protected by the law? And based on the information we know about how trauma is processed, reported, and also the impacts of PTSD and the individualized process of healing itself, updating our laws to eliminate protections for predators like a statute of limitations on reporting crimes of sexual abuse and sexual violence should have been done a long time ago. The excuses and rationale about this continued delay in justice have been frustrating. Something is better than nothing is simply unacceptable. I stand here today as a senator, as a rape survivor and advocate, and I will never stop fighting for that justice. Stop using this Constitution to block people from their pathway to healing. We know that abolishing the statute of limitations should have happened long ago. I stand here as one, but I represent the survivors in the balcony. I represent the 1 in 4 women and the 1 in 7 men who have experienced or will experience sexual assault or rape in their lifetime. I also represent the victims of child sexual abuse, the 1 in 4 girls and 1 in 6 boys who were victimized and most failed by adults and institutions, allowing predators to harm millions of kids. And these numbers are just victims who actually reported their abuse or assault or rape. Failure to update our laws to help those who have suffered at the hands of predators and protect future harm is unacceptable. I understand that this is the deal in front of us. I understand that a constitutional amendment is what's being proposed in House Bill 963. I understand why many of these survivors who've been in this building even longer than I've been, over 10 some years, fighting for this. They're here waiting for us to do the right thing. This bill ran in front of 962. So 962 has amendments that you could vote for a statutory window, meaning as soon as it's passed in the House, the governor signs it into law, not delaying justice for a minute more. People who are suffering from dealing with their trauma, whether it be with substance abuse or disorders, mental health issues, people are overdosing, they're dying. That's a real reality. So yes, I understand the yes vote on House Bill 963. But the vote of courage and the vote to do what's right is to add a statutory window amendment into 962. And I ask all of you to do the right thing. Thank you.
Chair now recognizes Senator Baker.
Thank you, Mr. President. No one can truly understand the pain of victims or their anger over a system that has discouraged them and a debate that at times disparaged them, and the urgency that they feel toward dramatic and irrevocable change. Fortunately, no one, to my knowledge, has come locked in a position that they want to do nothing. In the end, our differences come down to variant views on how and when remedies become available. This evening, I believe we have an opportunity to advance consequential change by enacting all 4 of the grand jury recommendations and offering greater protections for victims of child sexual abuse in Pennsylvania. Therefore, I rise in support of House Bill 963, which amends Section 11 of Article 1 of our Constitution to create a 2-year civil window for time-barred claims on child sexual abuse. My interpretation of the oath I took to support the Constitution leads me to this position. We properly think of the Constitution as remunerating our rights and enshrining our freedom, but it also contains limitations designed to prevent passion from overtaking reason. The Pennsylvania Constitution contains more rights and more limitations than does the federal Constitution. The framers realized situations would arise that were not even contemplated at their time. The remedy is to change the Constitution with the approval of our citizens, a deliberate process that ensures the change is thoroughly examined and deemed acceptable. The answer is not to end run the Constitution or to pass something and let the courts decide. That is an abdication of our legislative responsibility. There is an instructive point in this debate worth repeating. The prime sponsor of this proposed constitutional amendment was himself a victim of abuse. Does anyone really think he wants to delay or deny justice to victims? Does anyone really think he is looking out for the interests of a powerful lobby group? Does anyone really think he relishes being denounced and berated by the arch advocates of sidestepping the Constitution? No. He came into office committed to finding a solution and determined that a constitutional amendment is the long run, the most reliable and direct route. He's not making a casual or political judgment about someone else's situation. There is something more that can take place constructively. Until the time the voters render a judgment on a constitutional amendment, those organizations that had established victim compensation funds should reopen the window. Other organizations where abuse occurred should establish such funds to let victims make a decision on immediate recourse or broader recourse in time. We already know that some chose the fund and others continue to advocate for a fuller set of remedies. From the standpoint of law, pursuing the constitutional amendment route is sound and prudent. From a practical standpoint, it is a safeguard against a court ruling overturning the legislation we are endeavoring to pass. From a public standpoint, the referendum requirement ensures that people understand and approve of what we are doing here. And in our concern about litigation, we must take into account not just the legislation before us, but subsequent legislation that would seek to remedy other abuse cases that come to light. We may fervently hope that everything has been uncovered, but that is highly unlikely. Acting on this proposed constitutional amendment does not preclude or negate legislation underway. Rather, it provides the best guarantee possible for abuse victims that the sought-after changes to statute of limitations will not come undone with an adverse court ruling. I believe House Bill 960. Thank you, Mr. President.
The chair will recognize Senator Langerholk and then return to Senator Muth for additional.
and enact the 4 recommendations of the grand jury report. To the victims, you've hurt in a way that no one could ever know. We stand here today on the verge of truly historic reform. For years, you have toiled in this building. You've come forth, you've advocated, you've relived the horrors you faced, you've fought, you've struggled for something to be done. This institution failed you. We allowed the politics of division and misinformation and blame to quell any advances on this most important of issues. But not today. Don't let those same forces that have stood in the way of reform, don't let them rear their ugly head. We're here to do the right thing. The grand jury spent countless hours, countless time poring over testimony before they made their recommendations. My district is ground zero. My district was the first that was exposed the vileness and inhumaneness of the systematic cover-up of abuse of the Catholic Church. My district was one where a child predator doctor preyed upon his patients while a community supported him. It sickens me to no end to think of this evilness. Yet it pales in comparison to what so many of the victims dealt with and continue to deal with every single day of their lives. There truly can be no punishment severe enough for the monsters that perpetuate abuse on our youth. And the only consternation I take is that there exists a special place in hell for those individuals. And we're here today, many years later, and have a chance to finally enact legislation that will accomplish the goals of the grand jury. All four recommendations of a grand jury that heard the most wickedness of the wicked, of cover-up, of abuse, of secrecy, of pure, unadulterated evil. We can enact this reform today. Yet still, misinformation and division exists. And for someone who proposes to represent the victim, someone who proposes to represent them to make the comment that rather nothing be done than to add this a constitutional amendment, I ask, who do you serve? What interests do you truly represent? We know that whatever course is taken will result in appellate action. And sadly, no course of action will result in immediate justice. Nothing we do here today will change that. But what we can do is we can build a solid foundation and enact the strongest course of action. I've read the cases, the voluminous pages of opinion. I've read the various positions of competing interests. I can tell you this: I support a retroactive civil window, unequivocally. I support all four recommendations of the grand jury report. I'm not convinced that the remedies clause of the Pennsylvania Constitution makes this unconstitutional. My opinion is that that clause protects the rights of an individual to bring an action, not protecting the rights of a defendant in a statute of limitations action. Accordingly, this legislation will enable every voter in this Commonwealth to go to the ballot box and cast their vote on the constitutionality of this issue. That action will form the most solid of bases to withstand constitutional challenge. As our Supreme Court has held, and I quote, "Under either equal protection or due process, reviewing courts are the most justified in finding a classification permissible when it is enacted by the people as a constitutional amendment and does not offend the U.S. Constitution. Such a revision to the organic law of the Commonwealth of Pennsylvania will only be deemed to violate the Constitution that it amends, if at all, where the challenger has shown clearly, palpably, and plainly that the amendment is so unreasonable as to be considered irrational." This proposed constitutional amendment is not clearly, palpably, and plainly unreasonable. This constitutional amendment will withstand constitutional scrutiny. We can and we will make history tonight. I ask my colleagues today, stand with the victims. Do what we've tried in this building to do for so long, for too long. Give the victims justice. Give them the retroactive civil window. Give them the 4 recommendations of the grand jury report. Vote yes on this legislation. Thank you.
Chair recognizes Senator Muth.
Thank you, Mr. President. To prevent misinformation and divisiveness, I think we must be clear. There are other alternatives for justice, which is Senate Bill 540 that has all 4 grand jury recommendations in it. It also includes adult victims. As in regards to the funds, Senate Bill 540 doesn't prohibit a single fund from happening. It actually has a 6-month delay that allows any institution that wants to establish a fund to go ahead and do so. Because here's the thing, the bill that needs to pass has to be victim-centered. And that means the victim, the survivor, has their own choice in their pathway to healing and justice. That may be their day in court. That may be financial assistance to help with therapy. It's different for every victim. Giving them one route is not enough. These funds are not enough for each survivor. And that's just clergy abuse survivors. There aren't funds for other survivors. I know that there is going to be one amended into this with a lifetime cap of $10,000 for children that are victims and then $5,000 for adult. But the total cost of care for someone who's been sexually assaulted for rape in their lifetime can be anywhere from $87,000 to $210,000. It's not enough. And it's not that we can't do the right thing tonight. History can be made tonight in a bipartisan way where this has never happened before. This is the opportunity to vote on the right thing. And I'm still going to fight for this. This isn't a game over. This is what these victims are dying for justice. It is unbearable to not be heard. They've suffered long enough. Thank you, Mr. President.
The clerk will call the roll.
Bargle. Aye. Almond. Aye. Baker. Aye. Bartolotta. Aye. Blake. Aye. Boscola. Aye. Brewster. Aye. Brooks. Aye. Brown. Aye. Collette. No. Corman. Aye. Costa. Aye. Dinniman. Aye. DeSanto. Aye. Farnese. Aye. Fontana. Aye. Gordner. Aye. Haywood. Aye. Hughes. Aye. Hutchinson. No. Iovino. Aye. Carney. Aye. Killian. Aye. Langerholtz. Aye. Laughlin. Aye. Leach. Aye. Martin. Aye. Mastriano. Mensch. Aye. Muth. No. Phillips Hill. Aye. Pittman. Aye. Regan. Aye. Santicero. Aye. Scarnati. Aye. Scavello. Aye. Schwenk. Aye. Stefano. Aye. Street. No. Tartaglione. Aye. Tomlinson. Aye. Vogel. Aye. Ward Judy. No. Ward Kim. Aye. Williams Anthony H. Aye. Williams Lindsay. No. Yaw. Aye. Udechek. Aye. Mastriano. Aye.
The vote on the final passage is ayes 42 and the nays 6. This bill has been passed by the Senate and will be sent to the House of Representatives for its concurrence. Nice. The prior. The chair now recognizes Leader Corman.
Thank you, Mr. President. Mr. President, could we please return to page 4 of today's calendar and begin consideration of House Bill 962?
Leader Corman requests that we return to the calendar and take up House Bill 962. Will the Senate agree to the... I didn't see her. Okay. The chair recognizes Senator Baker.
Thank you, Mr. President. I rise to offer the following amendment and ask unanimous consent for its immediate consideration.
Senator Baker offers the following amendment and moves for its immediate adoption. The clerk will read the amendment.
Amendment number A, 4106.
Chair recognizes Senator Baker.
Thank you, Mr. President. This evening, we are making a concerted effort to reach agreement on changing the statute of limitations for victims of sexual abuse. For the sponsor of this bill, along with other members of both the House and Senate, this is deeply personal. For these individuals are survivors. We must acknowledge and thank them for their advocacy, commitment, and determination to right an egregious wrong. When the Senate Judiciary Committee held hearings several weeks ago, we indicated that the testimony would be used to help strengthen the bill before us. We listened to intensely painful and very impactful testimony from victims and survivors who shared their experiences and offered recommendations. And what we learned was the arbitrary age thresholds established years ago no longer are sufficient to deal with the horrific and widespread cases of abuse that continue to surface. Recent research findings and the testimony provided during our Judiciary Committee work tell us there is another age group of victims who deserve equal access to the remedies we intend to provide those below 18 years of age. The committee heard from Lakeisha Anthony, a student athlete at Kutztown University. During her first weeks in school, she described her excitement about being in college, participating in track and field, and meeting new friends. She talked of meeting another athlete, a person she wanted to get to know and spend time with. Unfortunately, that exhilaration went terribly wrong. And what ended up happening to her was sexual assault and life-changing trauma in her very first few weeks at college. But Lakeisha is one of the several survivors who offered testimony who were older than 18. So this amendment brings victims between 18 through the age of 23 into the bill. There are several significant factors that warrant addition to the complicated matter of providing redress to the many victims who have come forward and the unknown number who may yet do so. There are multiple studies showing that brain development continues into a person's early to mid-20s. There is a shocking prevalence of sexual abuse and assault cases reported by college students. In fact, 1 in 5 women and 1 in 16 men are sexually assaulted while in college. And more than 90% of these sexual assault victims on college campuses do not report that assault. We added remedies earlier this year when we included Senator Schwank's initiative about reporting so that the student wouldn't find them kicked out of college or impacted. And we also did the online reporting for anonymous reporting on college campuses. So we have clearly agreed that this age range is a vulnerable population. So the changes contained in the amendment provide for victims 18 to 23, a civil claim can be filed up until the age of 30. Right now, that law gives them 2 years. For the criminal statute of limitations, that will go up 20 years from the existing 12 years. Our prevailing concern must be with victims, irrespective of the place where the abuse occurred or the condition of the balance sheets of the institutions that may have condoned or failed to respond to the degree they were morally obligated to do so. We rarely talk about those survivors of abuse for whom any window may never provide a pathway to justice. And so with this amendment, along with our previous changes that added giving an opportunity for any child or adult survivor of sexual abuse to attain counseling through our Crime Victims Compensation Fund, that strengthens and enhances the underlying bill. The fund is the payer of last resort, but for many, it represents the only option. So in setting out to do the right thing for victims, we must not be limited in our determination as who qualifies, and therefore adding this important amendment strengthens and improves this bill significantly. And I urge an affirmative vote. Thank you, Mr. President.
The chair notices that Senator Argyle has returned from leave. On the amendment, the clerk will call the roll.
Argyle. Aye. Almond. Aye. Baker. Aye. Bartolotta. Aye. Blake. Aye. Boscola. Aye. Brewster. Aye. Brooks. Aye. Brown. Aye.
Yes.
Collette.
Are there any negatives? The clerk will call fast roll.
Argyle, Martin Street.
The vote on the final passage is, the vote on the amendment is ayes 48 and noes 0. The ayes have it, and the amendment is adopted. The chair now recognizes Senator Muth.
Thank you, Mr. President. I rise today to offer amendment number A03954 for its immediate consideration and affirmative vote.
Senator Muth offers the following amendment and moves for its immediate adoption. The clerk will read the amendment.
Got that crazy look in his eye.
Amendment number A3954.
Thank you, Mr. President. This amendment would strengthen and expand House Bill number 962 by providing timely protections through statutory changes and a pathway to healing and justice for all survivors of sexual violence and abuse, regardless of age. The way that House Bill 962 is currently drafted, it leaves out many survivors who were victimized after a certain age and also delays justice for several years because of the process required to pass a constitutional amendment. We as legislators, as public servants, have a duty to protect and serve all Pennsylvanians. My amendment provides a pathway to justice and offers all 4 grand jury recommendations. Specifically, it eliminates the criminal and civil statute of limitations for all survivors regardless of age. It also provides a 2-year statutory window for expired civil claims. We have seen at least 7 other states have statutory windows that have successfully helped survivors and have not been challenged in court. This amendment also clarifies and updates penalties for mandated reporters who fail to report child abuse and prohibits non-disclosure agreements that would prevent survivors from reporting to law enforcement. A truly victim-centered bill is a bill that will become law immediately. Making victims wait a moment longer for their rightful pathway to healing and justice is not only unnecessary, but hurtful and harmful. Victims of sexual abuse and sexual violence have already experienced tremendous, horrific, life-altering trauma. As a rape survivor myself, I know this struggle, I live this struggle, and there isn't a day that I wake up where I'm not a rape survivor. There is no statute of limitations or expiration date or time limit on the impacts of trauma. To not have your suffering recognized is an almost unbearable form of violence. You cannot heal if you don't feel heard. We do not need to wait years and years more to provide this pathway as a constitutional amendment would demand. We can do it now, today, in this chamber, by implementing a statutory window by passing this amendment. The lack of support for survivors, either by individuals or institutions like the government that serves to help people not protect predators, is a direct re-traumatization of every survivor. While we as lawmakers cannot legislate morality to make people think a certain way, we can legislate to deter certain unfavorable behavior. Abolishing the statute of limitations on sexual abuse and sexual violence crimes would deter predatory behavior and enforce accountability. Leaving a loophole for predators is irresponsible and harmful to our right to safety and protection by the law and by our government. I ask my colleagues to put party loyalty or special interest influence to the wayside and take this opportunity to finally do the right thing and vote yes on this amendment and finally give all survivors their rightful pathway to justice and healing. Thank you, Mr. President.
On the amendment, the clerk will call the roll.
Bargle. No. Almond. No. Baker. No. Bartolotta. No. Blake. Aye. Boscola. Aye. Brewster. Aye. Brooks. No. Brown. No. Collette. Aye. Corman. No. Costa. Aye. Dinniman. Aye. DeSanto. No. Farnese. Aye. Fontana. Aye. Gordner. No. Haywood. Aye. Hughes. Aye. Hutchinson. No. Iovino. Aye. Carney. Aye. Killian. No. Langerholtz. No. Laughlin. No. Leach. Aye. Martin. No. Mastriano. No. Mensch. No. Muth. Aye. Phillips Hill. No. Pittman. No. Regan. No. Santasera. Aye. Scarnati. No. Scavello. No. Schwenk. Aye. Stefano. No. Street. Aye. Tartaglione. Aye. Tomlinson, no. Vogel, no. Ward Judy, no. Ward Kim, no. Williams Anthony H, aye. Williams Lindsay, aye. Yaw, no. Udicek, no.
Vote on the amendment is aye 20 and no 28. The noes have it and the amendment fails. The chair recognizes Senator Muth.
Thank you, Mr. President. I rise today to offer an amendment A03961 to House Bill 962.
Senator Muth offers the following amendment and moves for its immediate adoption, and the clerk will read the amendment.
Amendment number A, 3961.
Senator.
Thank you, Mr. President. My amendment to House Bill 962 would provide a pathway to address the gap that leaves out many survivors in the age gap. Specifically, it eliminates the criminal and civil statute limitations for survivors regardless of age. Sexual assault or rape is no different when you're 17 versus when you're 19 versus when you're 23 like myself versus when you're 40, 50, or 100. Rape is rape no matter when it happens. This amendment provides a 2-year statutory window for expired civil claims. We have seen at least 7 other states pass this legislation. Again, I ask my colleagues to do the right thing and vote for justice and healing for all survivors now with a statutory window. Thank you, Mr. President.
On the amendment, the clerk will call the roll.
Argel, no. Almond, no. Baker, no. Bartolotta, no. Blake, aye. Boscola, aye. Brewster, aye. Brooks, no. Brown, no. Collette, aye. Corman, aye. Corbin, no. Costa, aye. Dinniman, aye. DeSanto, no. Farnese, aye. Fontana, aye. Gordner, no. Haywood, aye. Hughes, aye. Hutchinson, no. Iovino, aye. Carney, aye. Killian, no. Langerholtz, no. Laughlin, no. Leach, aye. Martin, no. Mastriano, no. Mensch, no. Muth, aye. Phillips Hill, no. Pittman, Regan, Santasero, aye. Scarnati, no. Scavello, no. Schwenk, aye. Stefano, no. Street, aye. Tartaglione, aye. Tomlinson, no. Vogel, no. Ward Judy, no. Ward Kim, no. Williams Anthony H, aye. Williams Lindsay, aye. Yaw, no. Judichak? No. Pittman? No. Regan? No.
Vote on the amendment is aye 20 and noes 28. The noes have it and the amendment fails. The chair recognizes Senator Carney.
Thank you, Mr. President. I rise to offer the following amendment and move for its immediate consideration.
Senator Carney offers the following amendment and moves for its immediate adoption, and the clerk will read the amendment.
Amendment number A, 3953.
Thank you, Mr. President. I rise to offer this amendment to fulfill all the recommendations of the grand jury report and to pass the statutory 2-year window during which child sexual assault survivors can revive claims whose statutes of limitations have expired. I agree with my colleagues, Senator Baker and Senator Longerholt, that we need to pass the 4 recommendations. I just believe that this is the way to actually meet those recommendations. We've listened to arguments for and against the window's constitutionality. The Attorney General argues that a window is constitutional. Courts have upheld child abuse civil windows in state after state. This very chamber moved legislation with the window last session. Case law regarding the remedies clause of the Constitution simply does not prohibit the revival of claims with expired statutes of limitation. We can't revive claims for acts that didn't used to be outlawed, but sexually assaulting a child has always been illegal. The same vested rights argument for why a window would be unconstitutional has been rejected time and time again in states that have enacted civil windows. Our statutes should reflect that, on average, people do not come to terms with their childhood sexual trauma until they are in their 50s. And that is what this bill does for future generations. But what of today's survivors? Our fellow Pennsylvanians have been suffering for so long, they've been waiting for justice and for healing. And like future generations, they deserve the right to seek justice and to heal. We should not put off that day when we don't have to. We should not make them wait for a multi-year constitutional amendment process that is not required. We have the authority to make this happen now. With the current makeup of the Senate, this is our last chance to do the right thing by survivors right now. I humbly ask all my colleagues to think about the survivors and to pass this amendment.
Chair recognizes Senator Gordner.
Thank you, Mr. President. I came to the Senate in 2003, and since 2004, I've been a member of the Senate Judiciary Committee. It has been a very interesting committee. It's one of the busiest committees, most active committees over the years. We were led by Senator Stu Greenlee for a long time, and now under the able leadership of Senator Baker. On October 2nd of this year, not too long ago, we had a hearing on these cases, a very emotional hearing in many ways. Many victims were there. There were many more in the audience. We talked about a lot of emotional issues, but we also talked about some bland issues like constitutionality. There was a constitutional expert there that said that a statutory window is unconstitutional. We had someone else say that it is constitutional. So we had arguments on both sides at that October 2nd hearing. There is a divisiveness of opinion. There is just a reference to our current Attorney General who says that a statutory window is constitutional. I can look back just 4 or 5 years and tell you we had an Attorney General who said that a window would be unconstitutional. So just in a 5-year period, one Attorney General says constitutional, one Attorney General says unconstitutional. I go back as far as 2013. I've got a letter here to the Senate Judiciary Committee and the Senate Aging and Youth Committee and the House Aging and Youth Committee from a very well-respected attorney from Cumberland County, Carlisle, as a matter of fact. As a matter of fact, I had his father as a law professor when I was a student. He was head of the moot court team that I was involved with. And he's just not some casual attorney. He represented Children Youth Services for many years. He co-founded the Pennsylvania Children Youth Solicitors Association. In 2006, he was selected as the Pennsylvania Bar Association's Child Advocate of the Year. In his very thought-out letter, he talks about why a statutory window is unconstitutional and goes into detail as to why a case that's been referenced, and any constitutional lawyer that talks about this is going to reference the Lewis case from 1908 because it continues to be that authority on the issue of constitutionality and something called the Remedies Clause. We've heard that a number of other states have adopted windows and they've been legal, but not many states have a Remedies Clause in the Constitution. And that's what makes the Commonwealth of Pennsylvania different on this issue. We don't have a Remedies Clause in statute. We have a Remedies Clause in the Constitution that you need to pay attention to. The constitutional expert who testified on October 2nd also had done a letter to the Judiciary Committee in 2016 when he goes into quite detail about it. He references that there's no like clause in the federal Constitution. This is something that the Pennsylvania Constitution and only a few other states have. And it talks about how the Remedies Clause protects vested rights, that is, a title, legal, or equitable to the present or future enforcement of demand or a legal exemption from a demand made by another. To that end, our Supreme Court has construed the clause to prohibit the legislature from retroactively eliminating an accrued cause of action. As for when a claim accrues under the Remedies Clause, the court has indicated that the date the law is frozen for a case is the date the injury occurs, and thus the date the cause of action and the relevant defenses accrue. And he goes on to talk again about how it applies to not just plaintiffs, but to defendants. It's a defense mechanism that can be used and has been used. And that 1908 case has been referenced a number of times over the years. As long as you continue to reference it and not overturn it, it is valid law, and that 1908 case remains valid today. And both in these letters that I talk about, these folks go on to make sure that everyone understands that it applies to defendants as well as defenses. And that's what we're looking at here. I bring up Virginia. It's interesting, my son was here today. My son's a second-year law student at Dickinson Law School. Got to look at the LexisNexis a little bit that the lawyers use and pull up a Virginia case from the early 90s. In that case, they passed a statute to open up a window. And that case ended up going to the Virginia Supreme Court. And the Virginia Supreme Court ended up saying that that was unconstitutional because they have a remedies clause as well. And so what Virginia ended up having to do was do a constitutional amendment because their Supreme Court ended up determining back in the early 90s that that action by the legislature was unconstitutional. Mr. President, we just took action on a piece of legislation to do a constitutional amendment. One of the senators that spoke very passionately on our side talked about how when you look at constitutional questions that are passed by the people that then go to the courts give those extra weight in regard to just a statute passed by the General Assembly. The other interesting thing, going back to October 2nd, and I forget, I think it may have been the chair that asked a question, And I think they may have asked a question to one of the proponents that said it is constitutional. If this statute is passed and it is tried and appealed, how long a process do you think it will take? And the honest answer that was given was at least 2 to 3 years. At least 2 to 3 years till it weaves its way all through the courts, hearings, appeals, etc. So 2 to 3 years. 2 to 3 years. We're almost at the end of 2019, at the beginning of 2020. So 2 to 3 years takes us to 2023, till possibly the Pennsylvania Supreme Court might make a final decision on a statute that is appealed through all the levels. In what we just did, by the votes of those of us that voted, we can do a constitutional amendment before that time. Why would we want to, again, as talked about, further delay the rights and what the folks in the audience and those passionate folks that spoke at the hearing talked to us about? A lot of experts, attorney generals of this Commonwealth, disagree on constitutionality. Is it going to get appealed? Is it going to go to the courts? Absolutely, positively, no doubt at all. The way to fix that, we did it. Constitutional amendment. We do it again next session. Doesn't have to go to the governor, goes to the people, and they make that decision. For those reasons, Mr. President, I would ask for a negative vote on this amendment, that we vote in favor of this bill, and that we finish providing all 4 provisions that grand jury had asked us to do. Thank you, Mr. President.
The chair recognizes Senator Farnese.
Thank you, Mr. President. I just want to rise and address some of the comments by my colleague on the other side of the aisle. He's right about that day, October 2nd, and that was a historic day, Mr. President, because that was the first time, and I've been on the Judiciary Committee as a freshman as well, too, and that was the first time the victims, that survivors, were ever allowed to come in to a hearing and be heard and remove the tape from their mouths and get that opportunity. So yeah, the opportunity, what actually happened on October 2nd was significant. And they weren't folks that came in and testified. They were victims, they were survivors, they were people. And they broke down and they cried. You know, Mr. President, the only thing older than this constitutionality argument is that Lewis case of 111 years old. I mean, when are we going to wake up? Let the courts do what the courts are supposed to do. In this chamber, we use this excuse, and let's call it what it is. We're not saving the court work. This is not judicial economy. It's an excuse. Because we know, people here know, that when we want to pass something out of this place, and the Constitution smacks us in the face, we run it. And we let the courts do their job. Let the courts do their job. Don't hide, Mr. President, behind a constitutional argument that we don't need to make. I don't know if this is constitutional or not. For every person that came in and testified, we had other people there that came in and testified too. Marcy Hamilton, CEO and academic director, Child USA. Robert A. Fox, professor of practice, University of Pennsylvania. What does she say? This year, Mr. President, has been a banner year for statute of limitations reform. 44 states and D.C. have considered legislation to extend or revive those statutes. Between 2003, 10 states have revived expired civil SOLs. In 2019 alone, 7 more states were willing to have the guts They knew about constitutionality. They knew about the Constitution. They knew what the role of the courts are, but they had the guts. Arizona, Montana, New Jersey, New York, Rhode Island, Vermont, Washington, D.C. Go see www.childusa.org, 2019 SOL. The point I'm trying to make is you could sit there and chop this thing up any way you want to do it on the statute and the constitutionality of same. But it's an excuse. You know, I sat in those hearings too. And the fact that the chairwoman was able to have those, and to the extent that she gave those survivors and those victims the opportunity to be heard, that's unprecedented. That's what's unprecedented. The work of Senator Baker to do that. We can do the right thing tonight. We're not alone. State after state after state after state had the guts. But even if you don't want to vote for it, stop trying to say it's not constitutional. That argument is old. You know it, and we know it. The courts are competent enough to make that determination. And when it's struck down, we start over. How many times have we had bills in this place struck down? When the NRA wants a bill, they get it. Who gives a darn about the Constitution then? We'll push that thing right through because they want it. Cases and cases of what's constitutional and what's not. We don't get to make that decision. We pass the bills, we do our best, we take the information, we attend the hearings, we listen to the testimony, and we weigh it. And we make a decision, and I'm fine with that. Make your decision. Vote your conscience, vote your district, but don't make the excuse that it's not constitutional. That's not right. Thank you, Mr. President.
Chair recognizes Senator Yaw.
Thank you, Mr. President. I rise in opposition to the idea of a statutory window. And I'm not going to repeat what my fellow attorney colleagues have said so eloquently, but on October the 2nd, we were told that there are significant issues, constitutional issues, with what's happening. And the provision of our Constitution, Article 1, Section 2, or Section 11, as the remedies clause, there was expert testimony that if we do a statutory window, it faces serious constitutional issues. You've already heard that what's happening by amending the Constitution, we are building a solid base, and a base that we can then pass statutory action that has substance to it, and it will pass muster. You know, unless I am totally forgetting what the oath was when I came into the Senate, and every member of the Senate took the same oath. And it says that we will support, obey, and defend the Constitution of Pennsylvania as well as the Constitution of the United States. Judges take that, but we take it. And I think that we have an obligation. When we are told by experts there's an issue here, we have an obligation to at least make the initial determination. Is this constitutional? And if we have significant reason to believe that there is a constitutional problem, then we should follow it. I think that, yeah, the statutory window, it sounds great. You get immediate relief. Well, you don't get immediate relief. What you get is a false hope. And the false hope then ends up in years and years of litigation. So we can either do years and years of litigation with the false hope, not knowing what the outcome is, or do it the right way and know what the outcome is. I think that what we're doing by saying, let's just let the courts decide. We're passing off an obligation that we have under the oath that we took. And I take that oath very seriously. And if the oath was, I have an obligation to support, obey, and defend the Constitution of Pennsylvania, then I have an obligation to interpret it the way that I think is best based on all the information that I have. And I think that there is significant evidence that's been presented by everybody who has spoken here tonight that says we have an issue here, and there is serious constitutional question. There is a process in motion that would solve all those constitutional issues, and I think we have an obligation to follow that. And for that reason, I would ask for a negative vote.
Thank you, Mr. President. I would like to submit a document for the record discussing the constitutionality of the civil window proposal regarding the Pennsylvania Remedies Clause. That was a memorandum from a senior appellate counsel stating how Pennsylvania's remedy clause simply states that courts shall be open and every man for an injury done him in his lands, goods, persons, or reputation shall give remedy by due course on course of law. On its face, then, the provision protects people who have been harmed, not those who have harmed them. It is the past victims of child sexual abuse for whom we now seek a remedy, not the abuser's enablers. Thank you, Mr. President.
Thank you, Mr. President. I'm also a member of the Judiciary Committee and was at the same hearing as some of the other my colleagues have testified already. I think that the either-or option that we seem to be presented with is really not the case. We can both have the constitutional amendment, which I voted for a few moments ago, as well as the window established statutorily. And so we don't have to really choose one or the other. And if the constitutional amendment process ends up with a more rapid pace, then that's the pace that we're on. Or if the statutory change ends up with a more rapid pace, that's the path that we are on. So we don't have to say one or the other. I do agree that there was quite a bit of dispute about the status of the Constitution. I, along with I think a prior speaker this evening, have come to the conclusion that our Constitution clearly permits the 2-year window, but I understand that others in this chamber may not agree. But we don't have to end with disagreement on an either-or choice. Today, by voting for this amendment, we can still go forward with the 2-year statutory window as well as what we have already voted for, the start of a constitutional change process. Thank you, Mr. President.
Chair recognizes Senator Gordner.
Thank you, Mr. President. I rise only to be able to submit to the record a March 20th, 2013 letter from Jason Kudalakis, as well as a May 27th, 2016 letter from Stephen Mikachik indicating that the statute is unconstitutional because of the Remedies Clause. Thank you.
On the amendment, the clerk will call the roll. Does the chair hear any objection to using the prior 2 calls? You're good. Okay. Clerk, use the previous 2 roll calls.
Gordner Martin Street.
The vote on the amendment is ayes 20 and the noes 28. The noes have it and the amendment fails. The bill will go over in its order as amended.
Mr. President?
Chair recognizes Leader Corman.
Mr. President, if you don't mind me a moment of personal privilege. We just dealt with two very emotional bills, House Bill 963, which we passed, and House Bill 962, which we'll pick up and supplemental in a few moments. The two sponsors of that bill, Representative Jim Gregory and Representative Mark Rozzi, are with us today, as well as other survivors. And no matter how you voted on this year, on these issues, I think it's important we all as a Senate stand and salute them for their courage for bringing this issue before us. If we could all give a moment to thank them. Thank you, Mr. President.
The chair recognizes Leader Corman.
Thank you, Mr. President. If we could return to page 5 of our calendar and begin consideration of House Bill 1051.
Leader Corman requests that we return to the calendar and consider House Bill 1051. Will the Senate agree to the bill? Agreed to. This bill has been considered on 3 different days in open Senate. It is now before the Senate for final passage. The question is, will the Senate finally pass this bill? The clerk will call the roll.
Bargle. Aye. Ballman. Aye. Baker. Aye. Bartolotta. Aye. Blake. Aye. Boscola. Aye. Brewster. Aye.
Are there any negatives? Judy Ward. Any other negatives? The clerk will proceed with fast roll.
Gardner Martin Street.
The vote on the final passage is ayes 47, the nays 1. The bill has been passed by the Senate and will be sent to the House of Representatives for its concurrence. What page is that? The chair recognizes Leader Corman.
Thank you, Mr. President. Mr. President, again, if we could return to page 5 of our calendar, begin consideration of House Bill 1171.
Leader Corman requests that we return to the calendar, page 5, House Bill 1171. Will the Senate agree? The chair recognizes Senator Farnese.
Thank you, Mr. President. Mr. President, I rise and ask for a unanimous consent to offer the following amendment. Ask for its immediate consideration.
Senator Farnese offers the following amendment and moves for its immediate adoption. The clerk will read the amendment.
Amendment number A, 3972.
Yes, sir.
Thank you, Mr. President. Mr. President, this amendment seeks to effectuate the true purpose of the statute, which is to shield the names of child victims of sexual abuse from public view. Under the current law, the names of parents filing lawsuits on behalf of their minor children are not shielded, which creates a loophole that easily allows perpetrators to discover and disclose the names of the affected children. This amendment will protect child victims of sexual abuse by automatically redacting the name of a parent or guardian who files a civil suit for damages on behalf of an injured child. Now, this amendment would still permit, Mr. President, it would still permit a judge to release the name to the defendant. However, those names must remain confidential, thus eliminating the risk of harm that public scrutiny may cause an already traumatized child. Mr. President, please join me in supporting this important amendment to protect our most vulnerable children and their families. Thank you.
On the amendment, the clerk will call the roll.
Argel, no. Almond, no. Baker, no. Bartolotta, no. Blake, aye. Boscola, aye. Brewster, aye.
The chair hear any objections to using the prior three amendment calls? You're good? Okay. The clerk will use the prior three calls. What do we want to do here?
Gordner
Call the
Martin
roll.
Street,
Call the roll. Oh, okay. All right. Oh, I
Brooks, no. Brown, no. Collette, aye. Corman, no. Costa, aye. Dinniman, aye. DeSanto, no. Farnese, aye. Fontana, aye. Gordner, no. Haywood, aye. Hughes, aye. Hutchinson, no. Iovino, aye. Carney, aye. Killian, no. Langerholtz, no. Laughlin, no. Leach, Martin, no. Mastriano, no. Mensch, no. Muth, aye. Phillips Hill, no. Pittman, no. Regan, Santasera, aye. Scarnati, no. Scavello, no. Schwenk, aye. Stefano, no. Street, aye. Tartaglione, aye. Tomlinson, no. Vogel, no. Ward Judy, no. Ward Kim, no. Williams Anthony H, aye. Williams Lindsay, aye. Y'all, y'all, no. Udichak, no. Leach, aye. I think so. Ian, no.
The vote on the amendment is ayes 20 and noes 28. The noes have it and the amendment fails. This bill has been considered on three different... Will the Senate agree to the bill? Agreed to. This bill has been considered on 3 different days in open Senate and is now before the Senate for final passage. The question is, will the Senate finally pass this bill? The clerk will call the roll.
Argel, aye. Almond, Aye. Baker. Aye. Bartolotta. Aye. Blake. Aye. Boscola.
Are there any negatives? The clerk will call fast roll.
Gardner Regan Street.
The vote on the final passage is ayes 48 and ayes 0. This bill has been passed by the Senate and will be sent to the House of Representatives for its concurrence. That concludes the calendar. The Senate will go at ease. The chair recognizes Leader Corman.
Thank you, Mr. President. Mr. President, notwithstanding the provisions of Senate Rule 12, I move that the Senate do proceed to consider House Bill 962 contained in supplemental calendar number 1.
Leader Corman moves that notwithstanding to the provisions of Senate Rule 12, the Senate proceed to consider House Bills 962 contained on supplemental calendar 1. All those in favor of the motion, aye. All those opposed, no. And the motion carries. We will now proceed to the supplemental calendar consideration of House Bill 962. The next bill on the calendar is House Bill 962. Will the Senate agree to the bill? Agree to. This bill has been considered on 3 different days in open Senate and is now before the Senate for final passage. The question is, will the Senate finally pass this bill? The chair recognizes Senator Carney.
Thank you, Mr. President. Mr. President, justice delayed is justice denied. We have put ourselves into a predicament here. The grand jury investigative report made 4 recommendations, but this bill is not one of them. To vote for this bill feels like a move in the right direction, but in reality, it is not what the grand jury recommended. If my colleagues on the other side of the aisle wanted to ensure that the grand jury recommendations were met, they could have agreed with my colleague, Senator Haywood, and pursued a dual path to providing these measures. But now the very Pennsylvanians for which this legislation was drafted will have to wait and wait and wait. This sends a bad signal to survivors of child sex abuse at the hands of the church and other institutions that we were supposed to be able to trust. It sends a signal that we have forgotten them and that we're leaving them out in the cold for at least 3 years. Because justice delayed is justice denied. But at the same time, to vote against this bill is to delay the improvements that it makes to our statutes and for our citizens going forward. This bill is not perfect, but it makes significant improvements to our justice system that many of our citizens will benefit from. Since we have the opportunity to make that happen at the very least, we must act. But justice delayed is justice denied. I stand behind our legislation, Senate Bill 540, and I stand with the survivors that this bill leaves behind. Those who think that this package will make the problems go away are sorely mistaken. I will keep fighting for all survivors of sexual assault. I will keep fighting for the survivors of heinous acts by rapists and their institutions that enable them. We will not take the pressure off our legislative leaders, and we won't stop until we ensure justice for all victims. Because justice delayed is justice denied. But we've waited long enough on these reforms, and we have a moral imperative to enact them. I will be voting yes on this bill, but we could do better. We must keep fighting for equal justice for all. Thank you.
Chair recognizes Senator Farnese.
Thank you, Mr. President. On October 2nd, as you heard, the Judiciary Committee, Senator Baker, held hearings on this issue. And in those hearings, we heard from survivors of horrific sexual abuse and assault. You know, I recall that afternoon, that entire day, like it was yesterday, because I know that there was never a day, the time that I have been serving, that I was ever moved by the testimony at the end of that hearing, by the survivors and the victims that came forward. It was nothing short of just incredible to hear them pour their hearts and their souls and talk about how they have been denied justice, denied the opportunity to speak, to be heard. Mr. President, they were denied the opportunity to grow and to experience life the way that each and every one of us deserves to experience it. These survivors have had their lives, childhoods, futures ripped from them. I could never, and I would never attempt to try to understand. But I remember, and it has stayed with me each and every day. I think about it. I think about their faces. I think about their testimony. And I think about how hard we worked to do more. I think about how they asked us that day for help. They asked us for relief. And today, we're not giving them what they need. We're not giving them what they deserve. I wish we could do more. I wish I could have done more. I tried. We tried. You know that. This is hard. But it's not over. We will come back and we will continue to fight. I won't forget that day. I won't forget those survivors that came there today that have got more guts than anybody in this building. And they told their stories. They asked us to help them. You know, you saw people here today, Senator Muth, Senator Carney, with their amendments, fighting and fighting and fighting. Unwilling to say no. Unwilling to say we can't do it because we know we can. If they can, we can. I'm sorry. So tonight, I promise, like all of us here, that we're not going to stop fighting until they get everything they need. And to that end, Mr. President, I want to tell a story. It's not my story. It belongs to my friend, colleague, and throughout this entire experience, this whole process, my inspiration, Representative Movita Johnson-Haro. These are her words. In the fall of 1985, I was 19 years old. On this particular day, I worked the 4 p.m. to midnight shift where I was training 6 new staff. All were girls, and they were high school students that worked part-time. Upon closing, we completed all the rounds and checklists together. At some point, I asked everyone how they were getting home. They informed me that they would be catching the Market Frankfurt line and then the 11 and 13 trolleys because all the girls were going the same way and they were all new to traveling this distance. And it was late. I decided not to get a cab and to take public transportation with them instead, Listen to these people. Listen. 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 By now it was after 1 a.m., and the streets were barren with the exception of the bar on the corner. When I got off the trolley, I began to walk the 2 blocks home, up 60th Street, looking around me to make sure I was safe. By the time I was about a block away from home, I noticed 2 men were walking behind me. I sped up my pace, and they did too. In a flash, he had run up on me and pulled me into the alley, a half a block from my house. One held a gun to my face and told me that if I screamed, he would kill me. If I screamed, he would kill me. Then one at a time, they raped me. Mr. President, this is who we stood up today to protect. This is who we stood up to protect. This is who we will continue to fight to protect. She and too many more like her can tell these stories, but far too many haven't. Silenced. Too long they've been silenced, traumatized, re-victimized. How many came to that day and talked about they were victimized over and over again? And they asked for our help. So today I rise to make the future better, and I pledge to continue to fight until we return every victim their voice. And again, I want to thank my colleague on the other side of the aisle, the majority chair, for her willingness, for her integrity, the way that she runs that committee, her willingness to have people be heard. Thank you, Senator. Thank you, Mr. President.
Chair recognizes Senator Muth.
Thank you, Mr. President. As we close tonight on this final vote, a step in the right direction, but we're leaving many behind. And I'd like to remind everyone that every 2 minutes in the United States, someone is sexually assaulted. 17% of those will be men, 25% are women that will be victimized in their lifetime. Less than 10% of victims report their assault to law enforcement. Less than 4% of college sexual assault victims report to police or campus security. Only 3%, if that, rapists spend a day in jail. If you're a man, you're more likely to be raped than falsely accused. Rape is the most underreported crime in the United States. As we move forward to continue this fight, I'd like to say thank you to the survivors who've been fighting for justice, who feel left out right now or maybe overlooked. I want you to know this, that every single one of you is worthy of being heard, is worthy of being protected, and having your rightful pathway to justice and healing now. Every single one of you has kept me brave, you've kept me strong, and I'm honored to fight alongside you in this continued battle for justice. The Survivor Army leaves no one behind, and I'm never going to stop fighting for us. And I'd specifically like to point out my colleague, Senator Collette, who's also a rape survivor. Thank you, Mr. President.
Chair recognizes Senator Baker.
Thank you, Mr. President. I want to thank my colleagues for their commitment to support the amendment that I believe strengthens this bill. And I also want to thank the members of the caucus across the aisle. Senator Farnese, Senator Muth, and I did meet to discuss our mutual interest in finding a comprehensive and legally viable remedy for this horrific problem of abuse and assault. We agree on many things, and they advocated for many things that are now included in this legislation. The same 4 members on this side of the aisle, Senator Langerholk, others who brought forward differing views on an approach to the solution. I don't believe any member of this Senate treated this as just another issue. Some members, as we've heard, experience trauma, personally or within their own family. Some members, and I'm among them, have long worked and volunteered with victims assistance and resource organizations. The revelations of such pervasive evil tear at our conscience and our soul. And what we learn is that the common assumptions about the responsibility of victims, their reactions, their path to recovery are often quite wrong, as we discover, to our dismay and frustration, that the law and decisions and policies are sometimes built on misconceptions. Today, we're moving forward to make that fix. We have taken a House bill which has been strenuously championed by another abuse survivor, received substantial testimony about it, and moved to strengthen it. This week, we have added significant counseling provisions, extended age limits, based upon what victims and service providers have asked and recommended. And so I stand before you asking for an affirmative vote on this important piece of legislation. Thank you, Mr. President.
Will the Senate agree to this bill? Agreed to. This bill has been considered on 3 different days in open Senate. It is now before the Senate for final passage. The question is, will the Senate finally pass this bill? The clerk will call the roll.
Argel, aye. Almond, aye. Baker, aye. Bartolotta, aye. Blake, aye. Boscola, aye. Brewster.
Are there any negatives? Negatives. The clerk will call fast roll.
Gardner Martin Street.
The vote on the final passage is ayes 48 and the nays 0. This bill has been passed by the Senate and will be sent to the House of Representatives for its concurrence.